Hi guys. This might be a little long and some might find it boring, but let's go over what qualified immunity is. And this is from the appeal, and let's just start reading. In our explainer series, Justice Collaborative, lawyers and other legal experts help unpack some of the most complicated issues in the criminal justice system. We break down the problems behind the headlines, like bail, civil asset forfeiture, or the Brady Doctrine, so that everyone can understand them. Whenever possible, we try to utilize the stories of those affected by the criminal justice system to show how these laws and principles should work and how they often fail. On the morning of November 23rd, 2004, Malika Brooks was driving her 11-year-old son to school when Seattle police pulled her over for speeding. When the officers gave her a ticket and asked her to sign for it, Brooks refused, believing that she had been wrongly pulled over and thinking mistakenly that her signature would be an admission of guilt. The officers threatened to throw her in jail, and when Brooks still declined to sign, a sergeant ordered her arrest. To push Brooks to step out of the car, one of the officers pulled a taser and asked if she knew what it was. She didn't, but she told the officer she was 7 months pregnant. The officer chatted in front of her casually, discussing which part of her body they would tase. "Well, don't do it in her stomach," one of them said. "Do it in her thigh." The officer twisted Brooks' arm behind her back and tased her 3 separate times, first on her thigh, then on her arm, then in her back, before dragging her into the street, lying her face down, and cuffing her. Brooks sued the officers to hold them accountable for their conduct. 6 federal judges agreed that the officers used severe force absent of any threat to their safety, violated the U.S. Constitution. Let me do that again. 6 federal judges agreed that the officers' use of severe force absent any threat of their safety violated the U.S. Constitution, but those same judges dismissed the case, relying on a legal doctrine called qualified immunity. The doctrine has become one of the chief ways in which law enforcement avoids accountability for misconduct, and as Brooks' case demonstrates, even proven constitutional violations, ordinary people, whether they be doctors, lawyers, or construction workers, are expected to follow the law. If they violate someone else's legal rights, they can be sued and required to pay for injuries they've caused. Under the doctrine of qualified immunity, public officials are held to a much lower standard. They can be held accountable only insofar as they violate rights that are clearly established in light of existing case law. This standard shields law enforcement in particular for innumerable constitutional violations each year. In the Supreme Court's own words, it protects all but the plainly incompetent or those who knowingly violate the law. It is under this rule that officers can, without worry, drag non-threatening 7-month pregnant women into the street and tase her 3 times for refusing to sign a piece of paper. Qualified immunity permits law enforcement and other government officials to violate people's constitutional rights with virtually impunity. Today we hear about the police shooting after police shooting, where officers are rarely, if ever, held accountable by the criminal legal system, either because prosecutors decline to charge, because grand juries decline to indict, or because juries decline to convict. Qualified immunity takes away the other avenue that victims of police violence should have available to hold police accountable. But while stories like Brooks' abuse of authority that go completely unremanded occur every day in our legal system, there is a coalition building against qualified immunity, and there is reason to be optimistic that things will change. The creation of qualified immunity. The Civil Rights Act of 1871, also known as the Ku Klux Klan Act. Interesting, huh? Congress gave Americans the right to sue public officials who violated their legal rights. In Section 1983 of the U.S. Code, the modern analog of a 1871 Civil Rights Act, Congress said that if a public official violates your rights, whether via police brutality, an illegal search, or an unlawful arrest, you can file a lawsuit to hold that public official financially accountable for his conduct. The language Congress used was unequivocally every state official who causes a deprivation of any rights granted by the Constitution and laws shall be liable to the party injured. Initially, the U.S. Supreme Court recognized the straightforward application of this law. In the case Monroe versus Pape, for instance, a black family, the Monroes, sued Chicago police officers who, in the early morning, broke into their home without a warrant, surrounded them, made them stand up naked in the living room, and ransacked every room, emptying drawers, ripping mattress covers. The officers then arrested James Monroe, the father, and detained and interrogated him for hours. In an opinion written by Justice Williams Douglas, the Supreme Court recognized that the Civil Rights Act allowed that the Monroes to sue the officers for violating their constitutional rights. The very purpose of Civil Rights Act, the court explained, was to give remedy to parties deprived of constitutional rights, privileges, and immunities by an official abuse of his position. Over recent years, however, the Supreme Court has largely gutted this promise. Did you hear that? The Supreme Court has largely gutted this promise. It has done this by creating out of a whole cloth of legal defense of qualified immunity and then vastly explaining it. The Supreme Court the Supreme Court invented qualified immunity in 1967, describing it as a modest exception for public officials who acted in good faith, that's in quotes, good faith, and believed that their conduct was authorized by law. 15 years later, in Howell versus Fitzgerald, the court drastically expanded the defense. The protection afforded to public officials would no longer turn on whether the official acted in good faith. Instead, even officials who violated people's rights maliciously will be immune unless the victim can show that his rights was clearly established. This is where I don't understand some of this stuff, because our rights are clearly established in the Constitution. It's written in black and white. It's clearly established, period. Okay, back to the article. Since the Harrell decision, the court has made it exceedingly difficult for victims to satisfy this standard. To show that the law was clearly established, the court has said a victim must point to a previously decided case that involves the same specific context and particular conduct unless the victim can point to a judicial decision that happened to involve the same context and conduct. The officer will be shielded from liability. So that's right there is where it all fell apart, because what they're saying is you have to have a prior case law, and how can you have prior case law if you can't sue the police officers? So or public officials. So that's why they can just run amok and do whatever the hell they want. The Supreme Court has recognized one exception to this rule in Hope versus Pelzer. Their corrections officers disciplined a prisoner by handcuffing him to a hitching post for 7 hours, with his hands above his shoulders, shirtless in the summer sun. At one point, a guard taunted the prisoner by giving water to a guard dog in plain sight. Faced with these circumstances and no prior case that had confronted similar facts, the Supreme Court ruled that officers' cruelty was so obvious that they should have had fair warning that their conduct violate constitutional protections against cruel and unusual punishment. Far from creating a meaningful exception, however, courts frequently consider the circumstances in Hope to set a threshold for how egregious an officer's behavior must be before he is considered to have fair warning. And that is the law today. An officer who knowingly violates someone's constitutional rights will generally be protected from suit unless the victim can identify previous judicial opinions that address the specific context, and conduct. This is a very fair afield from what Congress sought to achieve in the Civil Rights Act. Instead of considering whether a person's civil rights have been violated, and, if so, providing that victim with a remedy, courts shut their doors to victims simply because no prior judicial opinion happened to involve the same facts. Consider this example of how effortlessly courts use qualified immunity to sweep away serious constitutional violations. On April 2013, police officers in Texas responded to a dispatch describing a black man in a brown shirt who was firing his gun at mailboxes in a residential neighborhood. When the officers arrived, the man fired his gun in their direction and then hid himself from view. The officers set up a defensive position behind 3 vehicles and began ordering the man to put down his gun. A few minutes later, the officers saw Gabriel Wins, a mentally impaired 25-year-old, riding his bicycle, wearing a blue shirt and carrying a toy gun in his belt. Within 6 seconds of spotting him, the officers shot Windsor 17 times, chased him down, and tased him. He died at the scene. The officers later claimed that they shot Windsor because they feared for their lives. As in Brooks' case, a federal appeals court concluded that officers violating Windsor's constitutional rights by using deadly force against him when he posed no threat to anyone, but nonetheless, according to the court, the officers were entitled to qualified immunity. Entitled, they said. To support that constitution, the court offered one meager sentence of analysis. We cannot conclude that Gabriel's right to be free from excessive force was clearly established here. Pretty sickening, huh? Why qualified immunity is a problem. Qualified immunity hinders the protection of civil rights in a number of ways. First and foremost, qualified immunity means that victims of brutality and harassment by law enforcement generally get no relief from court and have no ability to hold offending officers accountable for their actions. That means the officers who commit the brutality and harassment I should turn my notifications off before I did this mirror, huh? That means the officers who commit the brutality and harassment and the government that employ them have little incentive to improve their practices and follow the law. This undermines safety and justice for everyone, and particularly for people of color or vulnerable people who are most likely to be the target of police misconduct. Qualified immunity doesn't just reduce a person's chance for victory in civil rights lawsuits. It means many claims will never be brought to the court in the first place. As part of a civil rights law passed in 1976, Congress tried to create an incentive for lawyers to represent victims in civil rights actions and ensue that constitutional rights are safeguarded. To do so, Congress granted that lawyers who represent victims in successful civil rights actions would be able to recover the cost of their time. A huge number of lawyers who bring civil rights actions rely on this law or on a possibility of contingency fees in the event they succeed. But when a case is dismissed based on qualified immunity, the victim loses and the attorneys are not able to recover fees for their work. Thus, as a result, the Supreme Court's aggressive defense of qualified immunity, victims of civil rights violations may be less likely to find a lawyer who is willing to represent them, and suits will not be brought in the first place. Qualified immunity freezes constitutional law. As mentioned previously, in order to overcome the defense of qualified immunity, a victim must show that law enforcement violated clearly established law by pointing to case arising from the same context and involving the same conduct. This has given courts a shortcut to resolve cases instead of reviewing, analyzing, and applying constitutional doctrine to determine whether a person's rights were violated. A court can instead simply say that there has been no sufficiently similar case in the past. The result is that fewer courts ever resolve constitutional issues, and constitutional rights are hardly ever clearly established. This shortcut has led to some outrageous results. In an opinion filed in March 2019, for instance, the U.S. Court of Appeals for the Ninth Circuit held that officers were immune from liability for the deliberate stealing of property simply because there was no clearly established case law. Let's do that again. This year in March, the U.S. Court of Appeals for the Ninth Circuit held that officers were immune from liability for deliberate stealing of property simply because there was no clearly established case law. So they have a license to steal, and the court said it's okay for them to do that. I mean, how can you make this shit up? I mean, it's fucking unreal. Governing the circumstances, that case, police officers who had executed a search warrant seized $275,000 in property, approximately $150,000 in cash and another $125,000 in rare coins, but stated that they had seized only $50,000. In other words, the officers attempted to steal $225,000 while on the job. The Ninth Circuit Court dismissed the lawsuit against the officers, granting qualified immunity because it had never before addressed whether officers executing a warrant could steal property and according to the court, it was not sufficiently obvious the police officers that stealing property under the guise of executing a search warrant violated the individual's constitutional rights. As a result, the Ninth Circuit said that it need not even address where the officer's stealing was legal. It's just sickening, isn't it? This is our public officials. These are our judges. These are the people that's supposed to be setting an example in our society. They're supposed to be protecting us. It's not there anymore, is it? This example should show the degree to which qualified immunity opens a door for wrongdoing on the part of law enforcement. No reasonable officer needs a case to tell them that stealing property is wrong. But it's worse than that, because the court did not say that the conduct was illegal. The law is still not clearly established that officers may not deliberately steal property when exercising a search, so an officer could again claim immunity over the same behavior. The Fifth Circuit Judge Don Willett described the phenomenon victims of abuse must produce precedent over. Let me start right over. The fifth judge, Don Willett, described this phenomenon. Victims of abuse must produce precedent even as fewer courts are producing precedent. Important constitutional questions go unanswered precisely because those questions are yet unanswered. It's confusing, isn't it? Courts then rely that judicial silence to conclude that there's no equivalent case on the books, no precedent equals no clearly established law equals no liability. I understand what they're saying. I don't know why I'm getting so twisted in my mind about reading that. In other words, Judge Willett said, heads, defendants wins, tails, defendants lose. So it's like the whole article's been saying. There's no way to win. You have no rights when it comes to dealing with police officers. They can do whatever they want, and we just read that they can steal, and the judges will say it's okay. Not just a judge, an appellate court judge. The Supreme Court has offered several justifications for the need for qualified immunity, but each has been debunked. Claim 1. Qualified immunity protects law enforcement officers from being bankrupted by civil lawsuits. One of the Supreme Court's principal justifications for qualified immunity has been that it protects individual officers from financial burdens of paying for lawyers and damage awards. However, that justification ignores the reality that such costs are virtually always paid by the officials or by the officer's municipality, insurance, or unions. A study of more than 80 state and local law enforcement agencies across the country found that in instances of misconduct, including those involving truly egregious, clear-cut abuses of authority, individual officers almost never paid such court costs. Claim 2. Qualified immunity protects law enforcement officers from the burden of litigation. Another one of the Supreme Court's arguments for qualified immunity has been that the public officials should be protected from distractions that go along with lawsuits, including having to turn over reams of documents and attend lengthy trials. But to that respect, qualified immunity fails horribly. A student of a Yale Law Journal of over 1,000 suits against law enforcement officers found that qualified immunity is rarely applied early enough in proceedings to protect officers from civil discovery, such as responding to document requests and depositions. That happened in just 0.6% of the cases studied. Claim 3. Without qualified immunity, law enforcement would be deterred from doing their jobs effectively. The Supreme Court's final justification has been that, absent qualified immunity, the threat of being sued would deter people from accepting high-risk jobs such as law enforcement and demand the ardor of people in law enforcement in carrying out their duties. Here too, studies have shown this concern is invalid. Study after study has shown that law enforcement officers do not think about the threat of being sued when performing their duties, and, in fact, many believe that civil liability is important to deter unlawful behavior. Qualified immunity as judicial policy making. Policy making is supposed to occur in politically accountable institutions like state and federal legislatures, which have expertise in crafting laws and ideally does so after engaging with all the relevant stakeholders. It is critical to note, however, that the policy to shield law enforcement via qualified immunity was made entirely by judges and not by any political accountable body. As described above, policy can drive Congress's intent in passing the Civil Rights Act of 1871. In its decision creating the hardening of the doctrine of qualified immunity, the Supreme Court has claimed that the doctrine is grounded in history. According to the court, public officials would have enjoyed a kind of qualified immunity under its laws as existed in 1871, the year Congress enacted Section 1983. The court therefore assumes that when Congress enacted Section 1983, it would have similarly intended that public officials would be granted qualified immunity. But there is one huge flaw in the court's explanation. Nothing remotely resembling the defense of qualified immunity existed in 1871. As Professor Jonah Schwartz wrote, several scholars have shown that history does not support the court's claims about qualified immunity. Common law foundations, indeed, there is a growing cross-ideological consensus that qualified immunity has no basis in history. In other words, each time the justices have chosen to expand the scope and effect of qualified immunity, whether it be requiring a victim to identify clearly established law, allowing judges to refuse and decline whether a victim's constitutional rights were violated, or ruling that law enforcement cannot even be brought to trial, they have done so not based on law, but based on their ad hoc policy determinations. In recent years, several justices of the court have begun to recognize this. Y'all are getting to see my text. In recent years, several justices of the court have begun to recognize this. For instance, in 2017, Justice Clarence Thomas analyzed the historical landscape and concluded that qualified immunity reflects precisely the sort of freewheeling policies, choices that the justices have disclaimed the power to make. How much more do we got to go? Oh, we're just about there. Let's go back to where we was. In the case Ziegler versus Abbasi, the Supreme Court granted qualified immunity to several high-level officials where it was alleged that they had conspired to detain a number of Muslim, Arab, and South Asian people in harsh solitary confinement based on their race, religion, and national origin. Justice Thomas wrote separately to explain that although no party had questioned the doctrine of qualified immunity in that particular case, the court should reconsider its qualified immunity jurisprudence in the future. The growing consensus that qualified immunity is wrong, although the Supreme Court itself has yet to retract the doctrine of qualified immunity, its foundation is starting to crack. As one federal judge has recognized, there is a growing cross-ideological course of jurists and scholars questioning its use. And in addition to the Justice Thomas, Justice Sayona Sotomayor, butchered that one, Sotomayor, in recent years has criticized the Supreme Court's qualified immunity case law, describing it as sanctioning a shoot first, think later approach to policing. Now, I don't know when that was said, but let's go over that one again real quick. Has criticized the Supreme Court's qualified immunity case law, describing it as sanctioning a shoot first, think later approach to policing, which is what we have now, and it's getting worse every day. That holds constitutional protection. Another federal judge similarly criticized the court for crafting its recent qualified immunity jurisprudence to effectively eliminate 1983's claims against state actors. The bipartisan challenge to qualified immunity extends to advocacy organizations, as well as multiple parties have filed petitions with the Supreme Court arguing that qualified immunity should be overruled. In 2018, and then again this year, organizations from across the political spectrum, including free market advocates, gun rights groups, the American Civil Liberties Union, and our own organization, the Roderick and Solange MacArthur Justice Center, came together to support the petition, arguing that the Supreme Court ought to abandon the defense of qualified immunity. Although the court has yet to take on the issue, momentum is building for future challenges. And I'll post a link to this. Sorry for my stumbling through it. Anyway, if you didn't know what qualified immunity was, now you have a better idea, and you also know why it's so dangerous and why it needs to stop. And I'm going to sign off with that, and I hope everyone has a good day, and I'll be interested in hearing your thoughts about this, and please like and subscribe if you haven't. Bye. Well, thank you for sticking around, those that made it to the end. I'd love to read any comments that you would like to leave, and just now you understand why qualified immunity has to go if you didn't before. It's the exact opposite of what this country is supposed to be about. It's given us a ruling class, and they don't have to live by the same laws that we do. They can kill, rape, murder, steal. I guess kill and murder is the same, huh? I said it twice because it happens a lot. and it's happening more and more frequently. The qualified immunity needs to go. This isn't what we need in our country. This is one of the big problems that we are having, and we're seeing a direct result from this what started off as kind of maybe is a good idea. You know, you can't turn around and get the police in trouble every time they write you a ticket or something or arrest you for something. I kind of get that in a way, but at the same time we have to balance it, and it's the opposite. It's the opposite of what balance is. It's totally out of control, and it needs to stop. So I'll leave a link in the description for anybody that wants to read the article themselves. And that foundation or whatever it is, they have several articles on different things that are very interesting, and will educate yourself on what's going on today and why. So with that, I'll close it up, and thank you for putting up with my stumbling and mispronunciations and pauses and text messages coming over the screen. I forgot to put it in airplane mode, but I'm not going to redo it again. So y'all have a nice day, and we'll talk to you later. Please like and subscribe if you haven't already. Bye.